Silence can convict you. Police legally use it as evidence of guilt. But there's a catch: specific words activate your protection. Say, "Nothing wrong," and prosecutors tell jurors you're guilty. The year was 2013. Genevieve Salinas was sitting in a Houston police station. He wasn't under arrest. He wasn't in handcuffs. Officers had asked him to come in voluntarily to answer questions about a double murder. For an hour, Salinas cooperated. He answered question after question. But then detectives asked if shotgun shells found at the crime scene would match his gun. Salinas went silent. He looked at the floor. He shuffled his feet. He didn't say a word. That silence would destroy his life. But here's where it gets disturbing. The prosecution used that moment of silence as evidence of his guilt. They told the jury that an innocent man would have denied it. His silence, they argued, was practically a confession. And the jury believed them. Salinas was convicted and sentenced to 20 years in prison. Now here's what makes this case terrifying for every American. The Fifth Amendment clearly states that no person shall be compelled to be a witness against themselves. That's the foundation of Miranda rights. You've heard it 1,000 times in movies. You have the right to remain silent. Anything you say can, and will be used against you. But here's the thing. Those protections only kick in at a very specific moment. And most people have no idea when that moment is. The Miranda warning is only required when two conditions are met. First, you must be in custody. Second, you must be under interrogation. If either condition is missing, police have zero obligation to read you your rights. And this is where millions of Americans walk directly into a legal trap. Voluntary interviews. Casual conversations. Friendly questions. None of these require Miranda warnings. And then the evidence changed, everything in Salinas's case. Think about that for a second. Every crime drama you've ever watched showed police reading Miranda rights immediately upon arrest. But that's Hollywood fiction. In reality, police can question you extensively before an arrest. They can knock on your door. They can approach you on the street. They can ask you to come to the station voluntarily. And during all of that time, you have no Miranda protection whatsoever. What nobody expected was how prosecutors would weaponize this gap. In Salinas's case, the prosecution made a stunning argument. They claimed that because Salinas voluntarily came to the station, because he wasn't under arrest, because he had been answering questions freely, his sudden silence on one particular question was incriminating. They painted his silence as the behavior of a guilty man who knew the shotgun shells would match. The defense objected. They argued this violated the Fifth Amendment. But the Texas courts disagreed. The case headed to the Supreme Court. Let me put this in perspective. The question before the Supreme Court was fundamental to American justice. Can prosecutors use a suspect's pre-Miranda silence as evidence of guilt? For over 200 years, the answer seemed obvious. The Fifth Amendment protects against self-incrimination. Silence is the ultimate form of not incriminating yourself. But the defense made a fatal mistake. They assumed the Constitution's protection was automatic. In June 2013, the Supreme Court issued its ruling in Salinas v. Texas. The decision split 5-4. And the majority opinion changed everything Americans thought they knew about their rights. Justice Samuel Alito wrote that the Fifth Amendment's protection against self-incrimination is not self-executing. That phrase is crucial. Not self-executing means you cannot simply remain silent and expect protection. You must explicitly invoke your Fifth Amendment rights. You must actually say the words. But here's where it gets truly disturbing. Everything I just told you is just the setup. The Supreme Court's ruling created a trap that most Americans walk into without ever knowing it exists. Here's how it works. Police approach you for questioning. You're nervous. You're scared. You decide to stay quiet on certain questions. You think you're protecting yourself. But unless you specifically say, "I am invoking my Fifth Amendment right to remain silent," your silence can be used against you in court. The courtroom went silent when prosecutors in subsequent cases began exploiting this ruling. They would tell juries that innocent people talk. Innocent people deny. Innocent people explain. Only guilty people go quiet. And juries believed them. Conviction after conviction followed. The dissenting justices called this a terrible outcome. Justice Stephen Breyer wrote that forcing suspects to speak in order to claim the right to remain silent turns the Fifth Amendment upside down. And this is where justice gets complicated. The Salinas ruling didn't just affect one case. It established precedent that prosecutors nationwide began using immediately. Defense attorneys watched in horror as their client's silence was paraded before juries as evidence of guilt. But wait, there's more to this case. Even people who know about this loophole often invoke their rights incorrectly. Simply saying "I don't want to answer" isn't enough. Saying "I want a lawyer" doesn't invoke the Fifth Amendment. It invokes the Sixth. They're different protections. The exact words matter in ways that can determine whether you spend decades in prison or walk free. Prosecutors have argued successfully that vague references to rights don't count. Courts have ruled that saying "I think I need a lawyer" isn't clear enough. That "maybe I should talk to someone" isn't an invocation. That "I plead the Fifth" said jokingly or uncertainly might not be honored. What happened next shocked the courtroom. Defense attorneys began fighting back with a new strategy. Education became their weapon. They started teaching clients the exact magic words. "I am invoking my Fifth Amendment right against self-incrimination. I am invoking my Sixth Amendment right to counsel. I do not consent to any searches. I do not wish to answer any questions." Those 4 sentences, memorized and stated clearly, change everything. They slam the door on the loophole. Prosecutors cannot argue that someone who explicitly invoked their rights was acting guilty by staying silent. The invocation itself becomes the shield. Legal aid organizations began distributing Know Your Rights cards. Civil liberties groups launched campaigns. Law schools added this gap to their criminal procedure courses. And something remarkable started happening. When defendants clearly invoked their rights from the beginning, conviction rates for those specific charges dropped. Not because guilty people went free, but because the legal playing field finally became level. Here's what this means for you. The next time you interact with police, whether you're innocent or not, you need to understand exactly when your rights apply. Before custody and interrogation, you're unprotected unless you speak up. The moment an officer starts asking questions, you have a choice. Talk freely, Invoke your rights clearly,